If you were arrested for domestic violence and you have your first court date coming up, then this video is for you because I'm going to be explaining 7 shocking things that might happen at your first court date. Especially if this is the very first time you have ever been arrested, then stay tuned because I'm going to be explaining these 7 things that when I was a brand new attorney about 11 years ago, that even though I went to law school, even though I passed the bar, I was surprised about. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to represent yourself at a restraining order hearing and win. So if in addition to dealing with getting arrested, you also were served with a restraining order, make sure that you get your free first class via the link down below. Okay, so let's jump right in. The 7 shocking things that might happen at your first court date in a domestic violence case. Number 1, it might be confusing once you get to the courthouse figuring out where to go. You show up at the courthouse, right? You go through security. What do you do then? Many times the paperwork that you are given is not going to have a courtroom on it. So the next step is that you need to look at the monitors. Now, at every courthouse that I have been to in the state of California, there are monitors there. Look for your name, and it should also have a courtroom or department telling you where to go. And even if you do have paperwork that does tell you maybe a letter and number, maybe a room number, department number, even if you do have something telling you where to go, double check the monitors. Number 2, your name might not be on the monitors. So I remember when I was first sent to court, this happened to me. Okay, I had my client's paperwork from their bail bondsman that did not have a department on it. I go to look at the screens, right? I'm like, you know what? I can figure this out. And my client's name is not on there. So I'm like, what am I supposed to do now? The answer is, if that happens, you should go to the criminal clerk's office. Depending on which courthouse you're in, there may be separate lines or there may be separate offices for criminal clerks, civil clerks, family law. So look for the one that says criminal. If they don't differentiate, it just says clerk's office, go there. You may have to wait in a line at the clerk's office. If that happens to you, do not panic. Your paperwork probably tells you to be there at 8:30. If you're in line at the clerk's office at that time, you are going to be fine. There's really nothing else that you really can do except for just wait in the clerk's office line. Of course, if you have an attorney, they will help you figure this out. Okay, now the really surprising thing here though is it's possible that your name might not be on the monitors. It's possible that the DA's office will still be reviewing the case on that day and that you may have to wait around for hours, or if you have an attorney, they might have to wait around for hours or come back to see if the case is going to be filed. Now, this can be a problem if it's a case where you can't have an attorney appear for you or you don't have an attorney. If you were planning to, let's say, go to work that afternoon, thinking that surely if your court date starts at 8:30, by the afternoon, you should be good to go to work. Number 3, once you get to the courtroom, when you go in front of the judge, one of the really surprising and really the worst surprise that you can get at your court date could be that either the DA, the prosecutor, or the judge tries to increase your bond, or maybe the police just gave you a ticket and you didn't actually have to pay bond. They may require you to post bond or post more. What that means is that you could potentially go to jail, go into custody, either while waiting for a bail bondsman, or if you are not able to pay a bail bondsman at that point. Now, I am not making these videos to scare you, and I hate when attorneys do that and try to use scare tactics. If you paid $50,000 bail, or if you were booked for a misdemeanor and your bail is $20,000 or $30,000, it is unlikely that your bail is going to be increased. If you didn't post any bail, your attorney should be ready to argue in your favor for why you should be able to stay out of custody without having to pay additional bail. But if it's filed as a misdemeanor, probably, as long as your attorney has some good arguments on your behalf, probably the judge will not require you to post bail. Now, when does bail get increased? That is if it was set too low. So if you have a felony case and your bail is $20,000, when I see that, I think 2 things. Number 1, you were probably polite to the police. Okay, so they did you a little bit of a favor there. But the other thing is I need to be ready at that first court date to make sure that I can argue for my client to be out of custody, because bail is typically going to be, for a felony domestic violence case, $50,000. So almost the default is for the judge to try to increase it to that. Other situations are maybe the police only made your bail $50,000, but there was like a gun involved, for example. Or later in their investigation, the police found out that the alleged victim had really bad injuries that they maybe didn't know about or didn't know the extent of when they were filing the initial report. For example, maybe the alleged victim's arm really hurt them. And they noted, okay, alleged victim has some arm pain in their police report, but then goes to the hospital, gets an x-ray, and finds out that the arm is broken. And this is, of course, if the alleged victim or the police are saying that you caused this. In that case, bond could potentially be increased. Another thing that the judge can do in regards to bond is order you to complete certain conditions. For example, in exchange for not increasing your bond or requiring you to post bond if you didn't, the judge could say, I want you to go to 1 AA per week, or I want you to go to domestic violence classes and take 1 per week. Now that seems a bit unfair when you haven't been actually found guilty of anything, but all the judge really has in front of them is a copy of the charges against you, and then whatever information your attorney and the prosecutor provide to the judge, usually orally, just explaining what's in the police report or explaining the good things about you. So if there was alcohol involved and you were extremely drunk and there's a lot of talk about alcoholism or excessive drinking in the police report, that's when you might be ordered to go to AA. Number 4, if it is a domestic violence case, then the DA, the prosecutor, is going to ask the judge for a protective order. This is something that can be very upsetting at your first court date if you don't know to expect it, because how it goes is that the DA will tell the judge what the charges are, usually. They will summarize the police report and make you sound like a really bad person. At this point, you might not have even seen the police report. You will not have your own copy at this point. Your attorney, to give you a copy, has to redact, black out some information on there. And your attorney will have just been given the police report probably a few minutes before. So the DA is going to read from the police report. And if you didn't know better, you might be thinking, am I being found guilty? Is this a trial? Why isn't my attorney saying that's not true? The thing is that for the protective order, what the judge can actually look at is not your defense, not, hey, this was self-defense, I don't deserve to have a protective order, or the alleged victim saying, I never even said that to the police. I never wanted this case to be open in the first place. Those are not things that the judge can consider. The judge can consider the charges against you, the allegations against you, which is basically a summary from the police report. If the alleged victim is there, then the judge can consider, but does not have to follow what the alleged victim wants. And if you have gone to domestic violence classes and the alleged victim also doesn't want the protective order, then the judge can consider the fact that you have done the classes. But it's not the time for your attorney to say that's not true. It's not the time to call witnesses or show evidence. It's mainly just going to be about the allegations. Now, why this is especially important is not just that it is upsetting if you are the defendant, but it's also important because the alleged victim, if they do not want a criminal protective order, a restraining order preventing the two of you from living together, from talking, any of that, then they need to show up for the first court date. Nobody tells them that usually. If you don't hire an attorney beforehand, or if your attorney doesn't typically handle domestic violence cases, they might not tell you that. And so the alleged victim not being told to go might stay at home, might go to work, and without them there, if they don't show up and talk to the judge and say that they don't want a restraining order, it will automatically be put on them by the judge. And the last thing that you want is your attorney, maybe it's a public defender, calling the victim because you can't, and you can't even contact them through a third party while they're at work or they're at home with the kids or something, explaining that, oh, this criminal protective order was put in place, and so for the next 30 to 45 days, until the next court date at least, the two of you won't be able to live together or be in contact. Number 5, will you talk to the judge or not? A lot of people wonder, is the judge going to ask me any questions? What about my side of the story? When do I get to explain what happened to the judge? The judge will probably ask you one question. And the question that the judge will ask you will go something like this. You have a right to a speedy trial. Do you waive and give up that right and agree that we can come back on blah, blah, blah date, and we will have your trial within 30 days of that date? What I just said probably makes not a whole lot of sense if you are new to this. Basically, what's going on there is that your attorney and the DA at that point have already agreed on a next court date. There has to be a next court date. You and your attorney have to look at the police report. You have to see what other evidence there is. Are there motions that can be filed? You shouldn't just plead guilty at that first court date, right? And if the prosecutor has already filed charges, they're not going to just dismiss on that first court date. And so what the judge is saying is, hey, you have a right to have your trial within a certain amount of time. Do you agree? Instead, we'll basically set it for a status date. If you are not in jail, then it does make sense to make sure that your attorney can actually look at everything. You can look at everything. You can discuss. You can formulate a plan before the following court date. So that is what the judge is asking you. And usually that is going to be the only thing that the judge is going to ask you. Your attorney, of course, whether you have a public defender or private attorney, is going to speak for you. They're going to enter a not guilty plea, but they are not going to tell your whole story that day, and neither will you. Number 6, another court date will be set. I've already pretty much explained this for number 5, but sometimes people are surprised by that because they think that everything will get done, like how it might with a traffic ticket, where maybe the judge sends you to traffic school or something and a fine, and that is it. But usually if you want a good outcome, then you are going to have to set at least one, but usually multiple court dates. Number 7, the prosecutor might offer for you to go to jail. So usually the prosecutor will have an offer. Sometimes they put it on a post-it or they write it on the first page of the police report that they give to your attorney. They will have an offer in the file for you. Sometimes they won't write it down. They actually won't tell your attorney, but on the record, basically when everybody's in front of the judge, they might give the offer, or the judge might ask them what the offer is, and they read it from their notes, and it might say 3 years summary probation, 60 days in jail, $500 fine, 52 weeks of domestic violence classes. It might be something like that. What do you hear out of all that? Jail, right? Jail. And I really hate when they do that because you see that the defendant is just panicking. Am I going to go to jail? Especially if it's your first time ever being arrested and there weren't really bad injuries. It's very unlikely that ultimately you'll end up in jail if your attorney is reasonably persistent, provides good mitigation, and if you are willing to come back for more court dates and not just take the very first offer. Sometimes your attorney will try to get you to take that offer. Now that sounds crazy, but let's say that you were in jail, you have no hope of bonding out, and you get an offer that lets you get out of jail or only stay in jail for, I don't know, another week or so, and at least then the whole thing will be over and you know you'll sit in jail anyway. Maybe that is tempting to you. That is actually how a lot of people, if they don't have money to bond out, end up with criminal history, which is really unfair. But there are also certain courtrooms where I have seen the public defenders pushing their clients on taking this very first post-it offer. Before COVID, this analogy made more sense, but that taking that very first offer was like paying sticker price on a car. How it used to be, at least, as most of us remember, is there would be a sticker price that you see on the lot or in the paperwork in the window, but nobody pays that. You have to sit there for hours generally at the dealership, go back and forth, and eventually you will get to a reasonable price. And the dealerships then, they know that nobody's going to pay sticker price. They expect this. For the most part, to me, that is what that first offer at that first court date is like. You're not going to take it. At that point, nobody has done any work on the case. The DA probably doesn't know very much about the case. Someone from the DA's office has probably spent a total of 5 minutes looking at your case, if even that. And of course, sometimes there are strategic reasons why you would want to take that first offer, but generally that is a terrible idea. And I don't know, if I hired someone who was supposed to professionally assist me with attempting to buy a car for the first time in the pre-COVID days where nobody pays sticker price, and they just walked me into the dealership and they said, you know what, we'll take that one. What's the price? Oh, sticker price? Great, sign me up. I think it's like that when attorneys, whether it is a public defender or private attorney, that is pretty much what you are doing, and that's the extent to which you are selling your client out. If without even doing any more work, within a few minutes of even getting the police report, you just accept the first offer or tell your client to take the first offer. Now, if the car was super underpriced or there was some strategic reason for you to accept that because it was a super great deal that was likely to go away or something, then that would make sense. If you didn't have time to negotiate for some reason because you needed a car right at that very second and you couldn't spend the time to just sit there in the dealership for several hours, if you are the richest person in the world, maybe it's not worth your time to sit there, right? Of course, there are exceptions to every rule, but the message here is that when you hear that first offer, you should not panic, and that unless there is a compelling reason why that actually makes sense logically to you, you should not be taking that first offer. I hope that you found this video helpful. If you do have a criminal case in California that you need help with, feel free to give me a call. You can find my number down below. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.